That's the best state to be in. Yeah. Right, okay, so we had a tremendous time yesterday with Mark. It was really good and very informative, and certainly, as someone that's never practiced here, I thought it was tremendously useful. You guys, got the inside track anyway, but I thought it was tremendously helpful to get the word from somebody that's out there doing it. And we have the tremendous honour today of having Elaine here. As she was saying, she has featured in some of these cases, possibly quite a few of these cases. So we'll get the inside goss on what happened in some of them. I think there was one I came across when I was prepping these cases where I think it was the lieutenant bailiff said that both advocates seem to have gone deaf, or both parties seem to have gone deaf in the course of the negotiations. So I don't think you were in that one. Yeah, I'll see if I can dig it out. Anyway, so if you cast your minds back to 2 weeks ago, when we were finishing up on the Sunday, we managed to get through to the end of chapter 10, which I believe, on my rather crude arithmetic, leaves us with 9 chapters to work through, 11 to 19. What I said to Elaine is that if at any point she wants to come in and make a point while working through the chapters, that is more than welcome. And in any event, I'll probably just ask her at the end of each section if there's anything that she wants to add, amend, contradict. So we'll see how we get on. See if we're still speaking after lunch. Right, okay, so discovery. Chapter 11. So first point, I guess, to pick up on is as a kind of general principle, then, as you can see in 11.2, pre-action discovery. The case on that is the Silver Falcon case, and I don't think there's too much to say about that. There's a little bit of, I guess, slightly interesting history. Obviously, it's quite an old case now, but as it says on, let's see, page 46 of the Guernsey Law Journal, the order that was made originally in the case, as it says, is a typical order for discovery made at a time when no action had been started. And that's the problem, really, in the Silver Falcon case. But I thought it was interesting that the paragraph then goes on, the procedure of discovery of documents was introduced here by the Royal Court Civil Rules 1989, obviously updated since then. Before then, it was unknown. So I think I did know that when I was working on the study guide, but it was nice to just be reminded of that situation, basically. And then towards the end of the judgment, the court goes on to say the true view of the rules, excuse me, is that they deal and deal only with the conduct of actions. And it follows that the powers that the rules confer on the Royal Court can only be exercised in actions. And Rule 39, which was the discovery rule, does not support the order against which this appeal is brought. So that's your kind of basic principle as far as pre-action discovery is concerned. And you can see there that there are specific situations, and I think we did look at those last time when we went through chapter 1 and then chapter 5 about those particular instances. I don't know, Elaine, if there's anything that you want to add about pre-action discovery at this point? Okay, right. Yeah. Okie dokie. So moving on then to standard disclosure. This is covered in part 10 of the RCCR, and it's usually the sort of thing, as it says at 11.3, that is dealt with at CMC. In terms of the obligation itself, you can see that list in 11.3, and I apologise again for the fact that my footnotes just reset themselves at the start of each chapter, which is obviously weird, and I don't know why it's happened. But anyway, so you can see that there are 5 aspects there. Documents that the party wants to rely on. Obviously, one of the key points, those documents that adversely affect his own case, documents that adversely affect another party's case, documents that support another party's case, and anything else that he's been required to disclose under any applicable practice direction. In terms of limitations on that, you can see that obviously it's subject to any claims to public interest immunity, and it's also limited to documents that either are now or have previously been under the control of that party. And again, you can see that's being defined as well in Rule 67 as is or has been in physical possession, has or had a right to possession of it, and has or had a right to inspect or take copies of it. And there's a very broad definition of document there. It says plainly intended to have the widest application, including things that exist digitally and exist somewhere on a server out in, I don't know, Palo Alto or somewhere else. Yeah. As far as the procedure is concerned, you've got two aspects to that. You've got your list of documents and your disclosure statement. So list of documents, I guess, is fairly self-evident there. As you can see, multiple copies, you often have multiple copies, particularly in commercial arrangements or maybe long-running disputes. So multiple copies there. Only required to disclose one. The only exception is where a particular copy, maybe someone's written a, kind of Maggie Thatcher kind of rubbish, or, please see me comment in the margin. There's something pertinent that needs to be drawn to the court's attention. Again, copy defined very broadly there. The second element, though, is the disclosure statement, which will give us the parameters for the search that has been made. And I think, again, this was a point that Mark just kind of touched on fleetingly yesterday in terms of searching. And I think it was when we were looking at, you mentioned briefly the whole kind of e-discovery side of life there. So thinking about the parameters, very... Mm-hmm.
What we call Action 599, we only have multiple copies, and some of them would have ability as draft on it to finish it from the final electrician's perspective, including person. There was any significance in the fact that we were the draft, which is a bit frustrating, but what you can find, and it's a way that we looked at in that one, is that when you're looking for percentage and similarity in the disclosure, it's really to know genetics, you can end up knocking out some of those agents. They're a bit difficult when you're doing that with your disclosure and your parameters.
I have a question in relation to the disclosure statement. Because it's 69, 69 that process may have been writing disclosure documents without the list into disclosure documents without disclosing disclosure statement. And it was my understanding that it's that statement which you sign, which you can then rely on to enable future disclosure application or that the other party. Why do the parties agree that purely cost statements are really simply discrete between the two countries? And there's also limited documentation, you might need to do that, and then it doesn't close people out from disclosure at a later stage. But in many cases, the simple ones you just might not need it. But then it's not that you just dispense with disclosure at all, because all you have to do is find a disclosure statement. You've got 5 documents, list them and say, I conducted research, and whatever you say. But without that statement,
yeah, well, I think you're right that the statement gives you the protection in terms of this is me saying what I've done. But if it is a straightforward just like document, in a sense, especially if it was on representing themselves, this gives you the facility to do that. So it's still and you're going to do that. Okay. So there's a solution there.
Yeah.
And we did it on the basis of CPR as we went in. Some of you may have seen that CPR 31 in particular has been subject to can have up, checking some of the work that's out there, so we can comment on it, because it's still regarded as being wholly excessive in this country. On parties.
What is regarded as really excessive?
It's the disclosure.
Yeah, or
Just generally, it was that I've done, which tended to be large certification, but people can be spending millions on this.
Yeah. Yeah, to come back to Julia's point, I mean, I guess it's one, the disclosure statement is going to set out your parameters, but even if you didn't have a disclosure statement, I think this other dimension, which is, you know, I am swearing or, you know, deposing to the fact that I've made a proper search for documents. I think even if you didn't have a disclosure statement, that would still be implicit in the agreement. You know, you'd be agreeing on the basis that a proper search had been conducted by your opponent, even if they hadn't told you exactly where they were looking. Yeah. Okay, so in terms of parameters, that's picked up a little bit in 11.6, your duty to search, and you can see then that the obligation isn't absolute, only needs to do what is reasonable, and that depends on a number of different factors there. And it's a continuing duty, as 11.7 says. So if you discover anything subsequent to the original standard disclosure, then you should make specific disclosure of that material. And I guess that perhaps begins to shade into something we'll pick up next Saturday when we think about professional conduct and that kind of tension between obligations to the client, obligations to the court, that type of situation. Okay.
Would you
Yeah.
include versions of the document?
Yeah.
Unless you've got several things that you can rely on, then that use development. I think it's always worth just to show that you know what you're talking about doing. When we switched in 2002, this year, we dropped what's called proving grammar discovery, and it moved from discovery to disclosure. So terminology is something that's important, otherwise it would get like me basically. But proving grammar was the thing of inquiry. So any document then leads to an inquiry. So now it's
Surely what you meant to say was fundamental to the administration of justice. Yeah, clearly. Yes. Or so you thought. So you thought. Right, okay, so there's not much point in having discovery or disclosure. No, that's all right. Unless you have the ability to have a look at these things. Not much point knowing they're out there if you can't actually see them. So inspection is an important aspect to that, and there is a right to inspect material that's been included in the list of documents subject to various exceptions. Elaine's already mentioned one, which maybe where you're putting up a claim to privilege. I think I've mentioned public interest immunity, and what else have we got? We've got without prejudice. So these are where the party making the disclosure would be claiming a right to withhold material from inspection. You've also got the category of documents that are no longer in the control of the party, so it's physically impossible, maybe legally impossible to get hold of them. And the third exception, I think, that the study guide identifies is that inspection would be disproportionate looking at the issues. I guess that's kind of coming back in the direction of the overriding objective, which perhaps we haven't mentioned enough so far. You know, keeping costs proportionate and reasonable. Mm-hmm.
Basically, it was over to our party and specify what the documents should be disclosed on the basis for us doing that, and we then had to consider the regime to disclose our own inspection, which was basically a confidentiality then for the advisors, which need to work. That's the only any other circumstance, I would.
Mhm. Okay. Right, okay, don't need to worry about that.
Yeah, and then any other judgment in
All right, I think another important point to pick up is at 11.10, you're entitled to inspect any documents being mentioned in pleadings or in a witness statement or affidavit or an expert report. So the right to inspect perhaps goes a little bit broader than just looking at the contents of what's on the list of documents. Okay, non-compliance picked up in 11.12. So as you can see then, the basic sanction is failure to disclose or allow inspection, means that you can't rely on that document in the proceedings unless the court gives you particular permission to do that, and that's Rule 78. And as I said in 11.12, if you're supposed to be disclosing material that either adversely affects your case or lends support to another party's case, then of course, as far as your client is concerned, they'd be sitting there thinking, yeah, great, who wants to rely on that anyway? Certainly not me, thanks very much. So yeah, as it says, where are the incentives to comply? Well, we come back, I guess, to you guys and your responsibility to assist the court to meet the overriding objective there. Mm. 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 That's always a good thing. All right, so withholding. Obviously, this is a situation where you are being transparent, if you can be transparent about withholding. But yeah, so 11.13. If you want to include something on your list of documents, but then say you're going to withhold it from inspection, or even before that, withholding it from disclosure, you cannot just make that decision for yourself. As it says, apply to the court for basically for permission to withhold it, and I guess for fairly obvious reasons that would normally be without notice application in the first instance. And as you can see, if the court agrees and makes the order, then that's not to be served on anybody else unless the court orders otherwise. 2 points then, when you're making the application for permission to withhold, you have to, as it says, assert both the existence of the right or the duty, which perhaps gets us back to Elaine's point about client confidentiality there, but also the grounds on which you claim to have it. So if you like, the evidence that backs that up. Yeah.
There were various applications for National Youth Commission, and the grounds in the officers basically there was cross-border cooperation, and there were some documents that the grounds in the officers did not want being gathered under compulsion, so they didn't want them to be used in closure and proceedings. So that's the sort of thing where, or if, for example, party was aware of a custody or just different, they might have been circumstances by officers who might want to check and not disclose that court if it's an ongoing one where we're still waiting for permission to deal with stuff.
I think that's actually, so I happened to, I was looking at collateral release the other day, and Chengiz was the first thing to come up. That particular case, which was, you want to use current documents. That's correct.
So you've got a whole chunk of decisions from England, and then you've got the Hazel Marshall one in July 16, I think, and then the 20th of October, you'll find this one in throughout its 2017 in relation to class reviews. It's become a big thing. Even Marshall, so February told it forward his decision in relation to class reviews. He said, oh yes, we'll go back to there and say, Hazel Marshall basically said she got it forwarded on the room the way that it's being interpreted in her judgment. Clear diversion to use what also perspective on the list in particular circumstances. It is real work. I don't know if I can make a master's because I would have thought class reviews can be ones that's likely to connect at some point. We've just got lots of easy material for the examiners to find stuff to ask you about. So that is all being changed under the CPR.
What was the case for Hazel Marshall?
It was Investigate Trust for Norway against the Investigate Trust against Norway. I can't find the right for me. I will give you the reference.
Yeah.
No, it was about, it was like a hearing, I think, in June 2016, the judgment came through.
I'm sorry, what was the name of it?
Investigate
I know, sorry, but that was
NBT.
Yeah. Yeah.
Yeah, it's a page, it's a page presentation.
okay, great, thank you.
So that's 3T, what is it?
Was it? Is it the 599?
So that's a. That investing one was the student, wasn't it?
It was what?
No, I don't know. much about that.
So basically, the Hazel Marshall one, we had proceedings in England for action plan, in which there was an obligation to produce documents in our client's possession, including documents received from the investment when our trial proceedings in 2012. So basically, we had to get classrooms permission in order to be able to even review those documents for purposes of because even reviewing use. We then had a fight with Rollins Hunter in relation to whether or not classrooms should be given and also how to deal with the process. Because what happened was we had scraped through the different disclosure tools to audio disclosure documents. We effectively sorted out the permissions to use it by students. We scraped through and found something like 15,000 documents that disclosures to the initial 7 terms. And then came the question of how do you work through that to work out if the should be given or not. And here the market just quite useful because we had suggested that we do a sampling approach, whereby we took maybe the first 200 documents and worked out a set of parameters for classifications, which is yes to that process initially. And then we rejected it precipitously after we spent quite a bit of time doing that and said no, the party was only used for the eventually flipped and moved it out to case. So we then had an army of about 25 lawyers basically reviewing stuff, and that's where the course comes from and the absurdity of it, because in the end of it, I think we had something like 20 documents out of those 50,000 that were actually being used on the English ones. Which still didn't get indemnity costs.
Yeah. Well, it's an interesting kind of parallel to the complaints that the CPS and the police are making in England and Wales these days, with thousands of entries in social media and things like that. Just the resources. Yeah. Well, that's very important. Okay, so all right, yeah. So the ex-party stuff is to deal with PII, because obviously, if PII is upheld, then it's important that the other parties aren't aware of that material, even existing. 11.16 deals with the professional privilege point there. That's really more to do with inspection, which I think was Jasmine's point there, really. And as you can see, it's possible for mistaken disclosure to occur, and that would trigger probably a decision under Rule 77 that the party that had been given inspection or had inspected in error would be prevented from using that material unless the court actually gave permission specifically for it to do so. And again, that begins to shade into issues around professional conduct, picking that sort of thing up before you've read it, that type of thing. Yeah. Okay, so moving on then to think about specific disclosure. You can see there the sorts of reasons for making an application for specific disclosure or inspection. So unreasonably limited search, specific disclosures needed to determine nature and scale of a particularly significant issue. We ought to force the respondent to explain what's happened to documents, maybe if they say that they have been in their control or possession, but they're no longer. Where have they gone? And then, as it says, really suggesting that privilege is a misconceived argument that's being asserted there. And you can see some counter arguments that respondents might put forward. When the court hears the application, then it's got the power to order disclosure either of specific documents or perhaps more usually a class of documents, or to carry out a search with parameters as laid down in the order, or disclose and disclose any documents that the search produces. As it says, the court may order the respondent to do all or any of those things. An example of disclosure, perhaps of a particular document, would be the Norman Piet against Hochtief construction. Very straightforward case where I think, if memory serves me correctly, it's significant parts of an agreement had been disclosed, and the concern there, as you can see in the text, concern was that disclosure simply of those parts and not the rest of it might lead the jurats to get a distorted view of the contents, and the court agreed there. You can see, particularly because there wasn't much of a counter response, no valid reason advanced for withholding the remainder. So they just said, yeah, you've got to hand over the whole thing. We can't have the risk of a distorted idea or understanding occurring there. As you can see, though, in terms of counter arguments, respondents can raise claims to LPP, and an example of that, Temesson against Butterfield Trust. Claims to both legal advice privilege and litigation privilege. And I don't think there's anything earth-shattering in that judgment. It's just a nice example of that sort of thing. And perhaps it also flags up one of those points that I mentioned earlier in terms of disclosure when documents are referred to in pleadings or witness statements, that type of thing. Paragraph 8 of the Temesson judgment, you can see there the court saying, well, even though at the hearing in September, the advocate had chosen to quote extensively from Mr. Mitchell's opinion, this is Andrew Mitchell QC, his legal opinion there, his legal advice to his client, even though the advocate had chosen to quote extensively from that opinion when he could have been more selective, and he could have produced, as his opponent suggested, a redacted copy of the opinion, I don't accept that the documents have thereby lost their privileged statement. Their privileged status. So it's both, I guess, an interesting illustration there. If you start reading stuff out in court, you could be held to have waived your privilege in that, but also a kind of recognition that not necessarily, but you're on thin ice.
Just say to them, got access to situations, so search documents, basically, what scope there was for information sharing, and I think he wanted that so that there was subsequently, if it transpired that there were different so I believe it is something that we could do as well.
Okay, so the use of disclosed documents, obviously the whole idea is to facilitate the particular litigation going ahead and then achieving the overriding objective. That's the basic raison d'etre for it. And as a result, therefore, the general rule is that you're limited to using that document simply for the purpose of those proceedings. And I think Elaine's already touched on that point. But as you can see, there are 11.21, there are exceptions to that situation. And one of those, 11.21a, document has been read by or to the court, and that's the point that was being made in the Tenasserim judgment there. And then the only other thing we got mentioned in there is quite a lot of detail, but I think we've probably thrashed that one to death now, haven't we? 11.22, the Chamber's discretionary trust. Yeah.
Which, you know, it says what it says. He's on Marshall one, because Hazel, though his judgment on still be slightly skeptical view on classroom use, but the other thing that you need to be aware of is that the Hazel Marshall one, those applications can go in the court to recode the documents with the classroom. And basically, that is a lot. So one of the points was Chamber's litigation has been on 10 years in the court of England and there's not much that's private once you've been through that kind of process, which is one of the things we were saying, you know, it's all just pointless. But they would argue there's certain documents in there that actually, why do you think that? Even after there's lots of time, we still have some privacy, so she could impose it. So she did recode some documents with the classroom use restriction, although I didn't actually agree in many instances those ones that practically done. So just bear in mind the legal position and also to contrast Hazel's judgment with Patrick Colbert's judgment.
Yeah, I keep making that argument on letting television cameras into his home.
Put a long drawn out battle, wasn't it? Always like to get comments from the Sorry. Another part of the transcript was printed with textures. I mean, it was I don't think, unfortunately, that made it into the judgment, although it's in the transcript.
Yeah. I'm just reflecting on that. That's the sort of remark that we'll have to think of a new version of that for the 21st century, won't we? Because people won't understand it. Yeah. Warped CD. No, it doesn't quite. No. So. All right. Okay. So that's chapter 11. Let's move on to chapter 12. I mean, I guess for good or bad, the only thing I can say about most of the remaining chapters is they're fairly short. So say maybe a positive, maybe a bit of a negative. We'll see how we go. But all right, so chapter 12 then is interim payments, and these didn't used to exist. So you've got a reference there to the Agenon and Pring case from 2005, where the court was tremendously, I think, sympathetic to the situation that the plaintiff was in there, but just noted that it had no power to do that. There was nothing in the Royal Court rules, 1989 as they then were, about that. There was no statute that permitted an interim payment, and the court didn't feel that it could invoke its inherent jurisdiction to do that either. So the court was, as I say, very concerned about that. And there is an interesting kind of follow-up to that, because there's a subsequent report in the same case, very short, it's only 5 pages, but Judgment 2 of 2005, where the Lieutenant Bailiff considered if the court had have had jurisdiction to order an interim payment, it would have gone about exercising its discretion to do that. So it's just, I think, a nice illustration of the process there, really. Okay, so yes, there's an amendment order from 2008, which has added, I'm sure you've all got the consolidated version, Rules 62A and 62B, into the RCCR.
My copy doesn't.
No, if they want to lie, it doesn't.
Oh, all right, well, okay.
Yeah, I don't think there is a version.
Isn't there? Oh, so it's just
Yeah. It's
all right. I'll take it back. Yes.
I actually haven't read those before.
All right. Yeah. So yeah. So all right. Well, there you are. So yes. So the court. Yes. Well. Oh yes. Mistaken disclosure. Yes. Yeah, yeah. Oh, yes. Wow. Right. Okay. So, yes. So we do now have a system for making interim payments since 2008. The primary rule, I suppose, is Rule 62A. And it seems to me that the scope of the payments is pretty much identical to what's in the civil procedure rules. So, power to order a defendant to make a payment on account of any damages, debt, or other sum, excluding costs. Although, of course, by way of confusing at least me, you can have interim payments of costs as well. But as it says there, which he may be held liable to pay to or for the benefit of the plaintiff if final judgment or order of the court in the current proceedings is given or made in favour of the plaintiff. And obviously the whole idea, the whole purpose of it is, you can see in 12.2, to reduce or remove the potential hardship the plaintiff may suffer as a result of delay in getting their hands on what they will eventually become entitled to. So as it says that you may be able to save assets that you would otherwise lose or pay for treatment, because of course this is typically ordered in PI cases. Have an asset repaired earlier and thus perhaps reduce the cost of repair, and of course that could actually work to the benefit of the defendant in any event. Okay, so power to make the order. As you can see, it's once we've got to the inscrete stage and the matter has been put onto the pleadings list, the plaintiff can apply and can apply numerous times. It's not a once only application. You can see then the requirements for the court to make the order set out in 12.3. Defendant submitted liability to pay damages or judgment that's been already entered for the plaintiff, simply for damages to be assessed. So we've had judgment on liability, we're just waiting for an assessment, or the court is satisfied if the matter went to trial, the plaintiff would obtain judgment in a substantial amount of money, excluding cost. And that tends to be the one I think that picks up the most decisions, the most litigation, really, or a variation on that third one, multiple defendants, and if the matter went to trial, would obtain judgment against at least one of them, even if the court can't currently work out which one. And as you can see, there are other requirements about defendant being insured or motor insurance, or if uninsured, it's going to be picked up by the MIB, or the defendant is a public body. In other words, there's money there and it's not going to cause massive issues to make an interim. No. There's a change in circumstances. Yeah. Okay, so 12.4, can't order more than a reasonable proportion, although again, that's kind of in the eye of the beholder, really. And the court will, in terms of working out the amount, take account of any counterclaim or relevant set-off, and certainly any contrib against the plaintiff. Where a payment has been made, as it says, And it could, interestingly to note there, it could be made voluntarily. You don't necessarily have to go to court. It could just be agreed there. And again, there may be there may be benefits for the defendant in agreeing to make that type of a payment anyway. So always something to think about. But that fact of the IP at all, not to be disclosed to the jurats, or if it's the judge alone, not to the judge either, as it says there, until all issues around liability and quantum have been determined, unless for any particular tactical reason the defendant has consented to earlier disclosure. Adjustment 12.6, that's a possibility as well. And I guess the other point I was going to pick up in 12.7 is that where you have several defendants, and one of them's made an IP to the plaintiff, the court can order another one to reimburse all or part. And as it says, it looks a little bit like an indemnity or contribution. You can only have this type of adjustment order for another defendant to come in and contribute to the IP where the defendant that made the payment has indeed claimed a contribution, indemnity, or other remedy against that second defendant. 12.8 just deals with kind of basic tidying up the housekeeping. So if it turns out that you've overpaid, then you can get interest on the surplus and obviously have the surplus returned to you. So fairly straightforward. I don't have any other cases particularly to refer to, but I did just, well, I'm going to mention it anyway. I can't show it to you because I know how to work the technology, and I'm sure you guys have all got excellent examples of drafts, templates, that type of thing, in your firm's archives to fall back on. But given that I don't get to see any of those, it was interesting. There's, I think, one of the cases that Mark mentioned yesterday was the Helmo and Simon case. It was just nice. It was interesting to see that actually in the judgment, which is I think 4 of 2010, that you've actually got the pleadings set out there. It's just a nice example to have a look at. As I say, you've probably got, you know, virtual shelf loads of these things. But Helmo, it was a road traffic accident. HELMOT.
Oh, it's quite a
Yeah.
Which,
Which is it the first instance?
Yeah, it's 4/2010 in the unreported judgments. Okay, but yes, yeah.
yeah.
Where there's further degeneration. Yeah.
Exposing an employer, but in that context, and one of the things that's quite interesting as well is that the Helmut model of damages basically multiplier was really higher. And what it in effect does is it creates the obligation almost to have private hospital infections in terms of the package. And in England, if you look at the law translation part, they accept that is what basically completely grounding in damages liabilities. They've adjusted the rate downwards, and I think we can get done that in Guernsey. So in Guernsey at the moment, if you look at the argument case with substantial damages, usually not death, substantial impaired, and then impaired, you still consider them at that massive expense bill in terms of their package. So I can see that as a way the states get around to adjusting it, it's just ongoing stuff which continues to be that like
Yeah. Back in the days when I used to teach on the old bar course, when we had General Paper 1, which was, as I was saying to you guys yesterday, it was a combined tort and crime paper. One of the things you had to do for tort, you get a set of case papers, and you had to write an advice and do some drafting. And when we used to teach those classes, my advice to the students, was always if you're in a situation where you've knocked somebody over, the most important thing to do is just stop, then put the car in reverse, and run over them, because it's much better to kill the person than just let them linger on. Yeah. Then they stopped me teaching it. I don't know why. Yeah.
Obstetrics and gynecology, obstetrics with Scotland,
Wow. Yeah. Yeah. No, thank you. Right. Okay. So, summary disposal then, chapter 13. Again, as it says, we've already thought about an aspect of this, which is the power to apply to have pleadings struck out, which can, of course, apply in whole or in part, and may be fatal to an entire action, or just maybe redefine the issues. So the thing we have to look at here is summary judgment, and that's part 4 of the RCCR. And again, you see under Rule 19, once we've got inscription on the pleadings list, then any party can apply to enter summary judgment against any other party. Yeah. Yeah.
I think there are probably 2 main scenarios where you would have it done.
Yeah, no, that's fine. I think it's important to clarify it.
And after winning a trial.
Yes, if you're having a copy.
If it's going to go to.
Yeah.
Yeah. Okay. So one thing, you're also young, that you probably don't remember the days when application for summary judgment was only something that would be dreamt of by plaintiffs and not defendants. Whereas these days, of course, anybody's free for all, really. But that's where we are. So as you can see, then summary judgment can be sought by the plaintiff on the basis of let me get this right. I don't know why I put it that way around. I should have done B first, because that's the way that I think of it. But anyway, so either the defendant seeks SJ on the basis the plaintiff no real prospect of succeeding on their claim, or defendant no real prospect of successfully defending, and no other compelling reason why it needs to go to trial. But that's the real kind of crux of it, no real prospect of succeeding, whichever horse you're riding in this one. So in terms of the application, it's a signification that is served on the other parties by the applicant. There has to be an affidavit from the applicant. That's Rule 21, and you can see the basic content set out at 13.5 there. The respondent obviously doesn't have to oppose the application, but they can do, and they should then file their own affidavit by way of response. As you can see, the court can order production of a document by the respondent, or even for the respondent to attend for questioning, so sworn evidence. Can do that even if it's a corporate entity that is defending there or responding to the application. And as you can see, it was said in Rawlinson and Hunter against ITG, which I think we have already mentioned in a different context. Yeah. Right. Yeah. So yeah, overall purpose is to prevent claims that are bound to fail from proceeding. So it should be seen by the court and by the parties, I guess, as a kind of weeding exercise. get rid of the things that are not going to survive or flourish.
I was worried this might happen to the house investment one. Couldn't see much more than that one, but not necessarily want to have your directors doing it because sometimes that can be uncomfortable in some regional context. You see, I think you doubts and reducing like that you might be able to succeed in Evans Lance bridge that one that you did. It was unfortunately similar on the argument that there may be an exceptional argument, and that's incredibly fact sensitive. So having a director being able to answer the things that were troubling the DB would not have been helpful.
As in just there at the hearing?
Yeah.
Not someone who was a witness, just sitting there.
Well, because we was the evident one recently with Peter Marshall, where the director or the trustees have to be in court, and we had 3 days to accept which was evidence on the point, and she just threw it in and said, right, okay,
Yeah.
which is a bit daunting, and also a little bit unclear about the fact that it's relative instance, but I think people need to be aware that there's that risk.
Yeah.
And strategically, we may need to play really clever game in terms of whether it's a good idea to have it available. I don't know if that inside. Yeah.
Oh, I think it's a very interesting practical point. Yeah. Okay, so let's have a look. Yeah. Okay. So a court's approach to all of this. You've got the reference there to the Rawlinson Hunter ITG case, and I think it's paragraph 11 that has the court there referring to the judgment in the Easy Air against Opal Telecom case from England and Wales. And as you can see, a readily accessible summary of the considerations involved when deciding applications for summary judgment. And having had a look at it again last night, I would say that I have, yes, summarized the readily accessible summary. So it's a bit longer in the actual judgment itself. So it's probably worth having a look at the original material. Paragraph 11 in the Rawlinson Hunter judgment. Yeah. Okay.
And the DP got to England and basically said, there's not enough here, but I'll give you a chance to answer. Which is a bit extraordinary. And one of the things, because I understand that generally speaking, if you're asking for the court indulgence to get the first right out, you would pick up with the draft amendment so that the court can see whether there's actually merit. No, it's not really that he was having a right to strike out here. A judgment is then a written amendment without we're actually really knowing what that amendment might say. So it's a complete waste of time. So I think if you're ever in that situation with in relation to that judgment, all the DP wouldn't like it because what you pay for. I think the point is the best practice is to otherwise
I think in that case, though, he was saying something along the lines of, I appreciate this is such a big litigation that's going on and on everywhere. I was throwing his hands in the air saying, and I know they all want to appeal anyway. So therefore, I'm going to let you because.
Well,
This presumes he got a case involved. Which is not, it's still not complete.
So it shows you how it can be open to that's the point. Well, yeah, I think there's much chance to maybe go actually quite an abundant or putting this over to actually made practice whatsoever, design total, all of those images.
Yeah. Well, interesting. That does. The only thing we've got left to think about is the powers of the court. And as you can see, then I'm sorry about this. The second 13.7. So powers of the court, which should be 13.8. Court can either dismiss or give judgment on the whole claim or on a particular issue. Dismiss a particular issue, give judgment on a particular issue. Make any other order that it considers just, which could include attaching conditions or staying execution of a judgment where it's appropriate to do that. And you've got a very, very short case note, the Trident Trust against Comprop Guernsey Limited case, which of course predates, it's 2006, predates the RCCR, but I think it still makes a valid point, which says to give summary judgment, the court must be satisfied both that there's no defence and that there are no fairly arguable points which the defendant could raise. All right, so maybe that's not quite the test that we've got in the RCCR now, but it does go on to say, if, however, there are points it could fairly argue, but there is doubt as to the way in which it has presented its case or as to its good faith, conditional leave to defend may be given. And I think that's still probably a good test for when conditions might be imposed by the court. I think shadowy defence is sometimes the expression that has been used in the past. And it may well be that a payment into court is ordered. So in that sense, at least, requiring the party, particularly if it's the defendant, to put their money where their mouth is, rather than being all mouth. Okay, so that was what else was I going to say? Oh yeah, the other point about that, I guess, is that even if you do get summary judgment, because that may only be on a part of a claim on a particular issue, then the surviving issues can go on, surviving claims can go on, and certainly if there's a counterclaim, then that can survive summary judgment. Yeah. Well, I think that's all fairly straightforward. Right, evidence, chapter 14. This is, yeah, do you want a break? Yeah, I just had a look at the clock. I mean, we've been going for, what, an hour? Yeah, since you brought all this coffee in.
I'm just terrified we're not going to get through it.
I feel like grinding those beans, yeah. Yeah, should we take 5 minutes? Yeah.
You go for it, guys. We'll have more than that.
Oh, dear. What, for everyone? Or just you? Yeah, there was almost a riot here yesterday. Like you should have been here yesterday. Yeah, it was all kicking off. Kate.
You are the wrong trio, and I did not answer that. You were doing it. And then I was like, tell me anyone else in Guernsey you can. Is anyone else in Guernsey you can? As much as you can copy it all day. I was like, then I just did it. Okay. And then you can enjoy that.
Yeah.
It's not she you.
Yeah.
It is moving on it, and other people, we put it out there as an offer. You can't be telling me this.
You just need more heads.
No, you're going to break their new system. No, I'm fine, thanks, Elaine. No, no, I'm so scared. Yeah, you're going to make me have a coffee. Have that coffee. Yeah. We don't want any quizzlings. Was that a hint? Bit like what? No, no.
Australian penguins, they've got holes in them.
Okay. What are they smuggling them in with?
It's amazing. They're just like penguins, but they've got holes in, so you can flip cheese them.
Should you wish to do so. Yeah. Okay.
It's
Well,
like a sim right? Yeah.
well, see, I'm assuming that clearly Penguin and Tim Tam have divided up the global market. A bit like Lipton's and PG Tips.
They're all holes. It's the one thing when you're on holiday, like, tea bags.
Yeah, Lipton's tea bags. What's that?
Yeah, notably looked at
Oh, what about the chocolate?
there's global chocolate shortage now, isn't there?
Yeah, I think, yeah, cocoa beans. Yeah, yeah. Mm. Yeah, I didn't realise I was watching, what was it, one of these BBC Simon Reeve programmes the other week, and he was in, I don't know, somewhere in Latin America, might have been Colombia, probably was actually, and they got this cocoa pod off the tree, and it's a huge, great thing. I mean, like about that kind of size. Because I was thinking, well, they're small. I don't know why.
I don't like, I've never even,
But
never even thought of it.
no,
They're
I mean,
big.
yeah, like that, like a cocoa pod. Yeah, it's about that big. And just cut it in half with your machete, and you've got all the goodies inside. Apparently, yeah, just eating it kind of raw, straight off the tree is, yeah, a real treat. Yeah. Although, to be fair, if you have to go to Colombia for that pleasure, I think I might be foregoing.
Yeah.
Yeah.
That life experience.
No.
Yeah.